I'm delighted to be here today with Geoffrey Robertson, an illustrious alumna from the ANU College of Law. Geoffrey, probably known to almost everyone watching this, has represented some of the biggest clients and some of the biggest cases in the world today. For instance, she has represented Julian Assange and Wikileaks. She's been involved in instructing Geoffrey Robertson QC in major cases in the UK. Before that, she was a Rhodes Scholar, a Brains Trust of the ANU, Rhodes Scholar. And it delights me to, as I say, to have Geoffrey Robertson here today. Let me start with your experience at the ANU. Can you tell us what you learned in your legal studies here at the College of Law that have been most helpful to you in your experience as a practitioner?
Well, the reason I chose the ANU as an undergraduate student was for the strength of the international law faculty here. At that time when I began my undergraduate studies, it wasn't common for there to be so many international law and international human rights law subjects as part of the undergraduate degree, and I thought that was a great strength of the ANU and continues to be today. And that provided me with a very solid grounding in the law that has been so useful in my career. But also I think what's been fantastic was the most life-changing thing about my time at the ANU was the combination of my Asian Studies degree and law degree and my ability to go and spend time living in Indonesia. I worked with a human rights organisation in West Papua, and bringing together those two disciplines of law and very practical work in country, which really helped me to give to find a context and a purpose for the legal studies that I was doing. And I think that combined interest of my Indonesian studies and language skills and the law, I've tried to bring that through in my career. And one of the most exciting cases I think I was involved in was assisting on a case in the Indonesian Constitutional Court in relation to help overturn the conviction of the editor of Playboy in Indonesia. So bringing together my language skills and my legal studies, and that came from my ANU time.
Did you appreciate before you married Asian studies and the law that social justice and human rights was an area you wanted to be involved with?
Ever since my first trip to Indonesia, I was very much interested in the sort of public interest side of the law, in helping people to improve their lives and to improve their situations. And working in Indonesia with a small human rights organisation really gave me that sense of purpose and a sense of fulfilment from seeing that happen on the ground, and the value in being a lawyer and the value in the law.
Let me ask you this. What has been the most challenging aspect of being involved in high-profile cases? And we can talk in particular about representing Julian Assange and Wikileaks. What have you found to be the most challenging?
Well, I think aside from the intense media attention and scrutiny of this case, has been the intense pressure and I think attention of governments towards this case. In particular, I have myself been the subject of a Lawyers' Rights Watch complaint as a result of the actions of the US government in their responses to Julian Assange and to Wikileaks, and to me in particular. There was some correspondence between the US State Department, and I communicated a letter on behalf of Julian Assange and Wikileaks in advance of Cablegate, which sought to address their concerns about risk to national security and risk to lives. Now, the response from the State Department, from Harold Coe, was a letter that was addressed, "Dear Ms. Robinson and Mr. Assange," including a number of over-exaggerated and unsubstantiated claims saying, "You are about to publish in breach of US law. You are about to put lives at risk. You are doing this without regard to the grave consequences of your actions," as if I was somehow in joint enterprise. And that was seen as a direct attempt to try to interfere with Julian Assange's right to representation and to put me at risk. This was at a time when Julian was, of course, the subject of assassination threats from very high-profile Americans, and I suffered similar threats after that. That was the subject of a Lawyers' Rights Watch complaint. And subsequent to that, it was very publicly became a big news story, I guess, last week when I was informed at the airport on the way down here that I was on an inhibited travel list. Now, we still haven't got to the bottom of that, but it's this sense of surveillance, of being watched, that as a lawyer you should never have to experience. But unfortunately, in some of the cases that I've worked on before, in this case and in some of the work that I did in West Papua, that has been a reality of working on controversial cases where your client or the people that you're representing are challenging government power.
In representing oppressed or vilified clients, and receiving death threats, is that something you had anticipated, and is it something you're willing to continue to bear?
As a lawyer, it's very important, I think, that there is a distinction between you and the client, and that's certainly what's enshrined in the UN Basic Principles on the role of lawyers, and it's something that I have faith in and put a lot of stock in, I think. Look, I believe that as a lawyer we are doing what's right, we are protected by law, our role is protected by law, and when you know that you are standing up for what is right, then I do believe that the law will ultimately offer protection. And unfortunately it can be a reality of acting in these sorts of cases.
Does this sort of cause lawyering, as some call it, lawyering in the advocacy of social justice, for example, do you see that as undermining perhaps the dominant paradigm of the legal profession, where we teach our law students, and as lawyers we tend to think about the law as neutral and objectively applied? Do you think cause lawyering has an impact on that traditional stance?
I think it does, but I don't think it undermines it. I think in some circumstances it can only enhance your role. Of course, the law is objective, judges are certainly objective, but as advocates we are required to be partisan, we are required to forcefully argue our client's case. And of course we don't have to feel that we more necessarily agree with what the client has done or intends to do. But it's certainly, and I think that's an important backstop, because if we were required to agree with what the client does, then there would be a bunch of clients out there who would never get representation. But I do think that in certain circumstances, if you do actually believe in the principle of the matter, then lawyers shouldn't be afraid to say so.
Yes.
And in fact, it can make you a more passionate and indeed stronger advocate.
Do you think it can cross the line, though, and make you look more like a politician rather than a lawyer, for example? If the law that's being advanced, for example, or the argument being made about the law is one that is trying to progress things rather than representing the law as is?
Well, I think that's an important, law reform is an important aspect of understanding law reform, and legal process is an important aspect of being a lawyer in my view. And if you see, we shouldn't purely understand law and justice as being the same thing, because often the position that the law represents and the legal position may not always be just. And I think that it is important that as lawyers we recognise that, and if we believe that the law is not rendering a just outcome, then we advocate for change.
So in representing Julian Assange, for example, did you share responsibility, for example, for the ends that your representation was being sought, for which your representation was being sought? I
think that it's important to make a distinction between lawyer and client. This distinction between lawyer and client, which is protected by international law, by the UN Basic Principles on the role of lawyers. This is incredibly important, because lawyers should not be conflated with their clients and their clients' actions, and that's an important part of protecting the independence of lawyers. At the same time, I do believe in free speech. I do believe in greater protection for sources. The law does not provide, the world over, does not provide adequate protection for sources for the media. And Wikileaks is providing, through technology rather than law, protection that has what we haven't seen before.
Right.
And in that sense, I do think that Wikileaks is a fantastic development. I do believe in greater transparency. I do think that there are fundamental problems with freedom of information. Does that mean that I represent the ends that Wikileaks seeks? In some ways, I guess I do believe in those ends, but does that make me responsible for every action of my client? Absolutely not.
Right, yeah, and I fully appreciate that view. The basis for my question, maybe I should explain that a little more. Coming at it as a public interest environmental lawyer, for example, oftentimes these sorts of lawyers have the privilege of deciding who the client is and more or less deciding what strategies or outcomes are being sought. That oftentimes confuses duties to clients driving litigation rather than lawyers driving litigation. I was basically interested in whether any of that had come up in for example, the WikiLeaks case or in any other case that you've been involved in.
Well, in some ways, yes. If some of the issues that are affecting WikiLeaks, for example, the financial services blockade, WikiLeaks has been cut off by MasterCard, Visa, PayPal, Western Union, in ways, I think, which raise very fundamental questions about the ability of consumers to donate to not-for-profit organisations, for example, like Amnesty or Greenpeace, and thinking about actually taking proactive cases to challenge that position,
Yes.
which has more systematic implications in a broader sense, a more public interest sense. In this case, I think it would be both in WikiLeaks' interest and in the broader public interest to run that case. But you're right, these questions do come up. But I think it is you always have to keep in mind your duties to the client and whether the particular case that you seek to run is in their particular interest.
Let me ask you this: how has representing Mr. Assange at WikiLeaks changed, if at all, how you view the legal profession? Has it had an impact from law school to practice?
Absolutely. I think this is a case that's received a huge amount of media attention and, in many cases, misinformed media attention, inaccurate reporting. And one of the things that I have seen the most out of this case is the fact that, yes, legal cases are definitely argued in the courtroom, and that is our primary duty as lawyers, but there is oftentimes, it is very important to also remember that there is the court of public opinion, and that can be very important in certain cases, and this has been one of those.
So that's very interesting, because that was going to be my follow-up question about, strategies or tactics outside the courtroom in order to advance clients' interest. I think everybody has seen lawyers giving media, press releases and media conferences about particular cases. Are there any other strategies that you've developed or become familiar with as a result of needing to meet both the courtroom and the politics, as it were, of the case?
I think also making representations to members of Parliament to make sure that they're properly informed about the legal case involved, what ramifications that might have politically. Of course, Julian's extradition case in particular has been a highly political case and a highly politicised case, and one that has ramifications for our government, for the Australian government, for our Foreign Affairs Department, for the Attorney General, and in terms of our relationships with both the UK, with Sweden, and potentially with the US. And it has had a huge amount of traction with the Australian electorate as well. Julian certainly has a huge amount of support in Australia, and Australians do not want to see him extradited to the US for the work that he's been doing with WikiLeaks. So in a sense, it does become a political issue, because they're making representations to members of Parliament who can actually take action and certain actions and make representations to other governments about these cases can also be rather important.
On the extradition issue, this is a personal question that I've always had an interest in. The worry is extradition to the U.S., and I can see that being of concern. I'm just wondering, though, isn't it more likely, at least it's always seemed to me, more likely that Mr. Assange would be extradited by the UK than, for example, the state seeking his extradition?
It has been a common question, and there's been a lot of discussion about this particular point. My view is, irrespective of the relative ease from either jurisdiction, the concern is that extradition to the US may be a possibility at all for what has essentially been the same act that was engaged in by the New York Times. But in his particular case, it was the timing of the warrants as they arrived. The warrant from Sweden in respect of the alleged sexual offence case came before the US had even announced a criminal investigation into WikiLeaks publicly. And so because that arrest warrant had come earlier, if the US were to request his extradition from the UK, it would be a matter of the Home Secretary having to determine between two competing extradition requests from two separate countries. That decision would be subject to judicial review. And aside from the legal questions that would raise, John Bellinger, who's a former White House legal advisor, said in December 2010, in response to this same question, that the US government would be very unlikely to request his extradition while the pending Swedish request was there. And the US ambassador then went on to television and said specifically that the US would be waiting to see what happens with respect to Sweden. And so it's actually a matter of practical a practical matter. Now we're waiting for the Supreme Court decision. I'm no longer formally instructed in that case. It's being handled by an incredibly experienced and well-known human rights lawyer, Gareth Peirce. But her view is that irrespective of the outcome of the Supreme Court decision, if he wins, it's very likely the US will seek his extradition from the UK. And of course then, as you said, the UK-US extradition agreements aren't known for their protections for those facing extradition.
Interesting. Let me follow up with the future. You mentioned you're no longer formally representing Julian Assange.
In the extradition proceedings.
In the extradition proceedings. But you've taken on a new position recently as legal director for the Bertha Foundation, and I'm wondering what that involves and the opportunities for social justice there, and what you envision, growing that organization.
Bertha Foundation is a very new foundation. I've been brought on to create a global public interest law program working together with progressive public interest law centres around the world. We already have an existing relationship with the Centre for Constitutional Rights in New York, and we're also working with the European Centre for Constitutional and Human Rights in Berlin, and looking to develop a program which helps to support young lawyers into this area of practice, and to develop networks around the world through which we can support strategic human rights litigation, both on a domestic level and transnationally. Because of course we have issues, for example, with multinational corporations engaging in certain behaviour in developing states, and often the best way of making them accountable is going back to the home state's jurisdiction. And so we're looking to support cases along these lines.
Excellent. I hope you look at some ANU young lawyers in connection with the Bertha Foundation.
Absolutely.
I think that answers the questions I have for you today. So thank you once again for being here.
Thank you for having me. Great.
Thanks.